always put it. I'm about to turn it down.
I ain't got shit to prove, but I got shit to lose, so I can't go around acting a fool. But if y'all get the rules, gonna be broke at the tool and he let
No,
that shit
his, not yours. No, it was fine. You just got pushed. You do it this way.
Bitches jocking my moves, imitating my boots, sometimes I feel like losing my fear. I ain't got shit to prove, but I got shit to lose, so I can't go around acting a fool. But if y'all get the rules, gonna be broke at the tool and he let that shit go like a ball. To make him in the street, so y'all supposed to say two big bodies, and y'all better make room.
No, not yet. Not yet. Okay. You ready?
But don't get it confused, they just want me to use for the clout of them big bitchy blues.
We are on.
That's true, you know why that's going, that's straight to my shoes.
On Mevo, Facebook, yeah. Not that.
Someone go scream my name if it's true, I don't bang with you.
You gotta look at the one on Mevo.
True, but I can't give up, think I'm in love with the fool. I'ma say that I think I can't even debate.
Aliens.
Chicks that check who was back, tell them give me that next day you love me, you gon' have to prove. Tell me I gotta watch what I say, but I'm watching out right down like 10 every day. I don't sound like nobody. So
learn something today.
They was looking with some family. I be posted on Washington, if I'm not body, your tracks are performing for profits. And yeah, I'm still true to topic, I need a biotic for this. Writing while I listen.
You want a Mevo one? The Mevo one?
You know I'm packing them. Pull up that package then. So up, you can just liking it. Displaying something more than averaging. Catching up, but there ain't no traffic there. Bitches jocking my moves, imitating my boots. Sometimes I feel like
what's that for?
I ain't got shit to do, but I got shit to lose. So I keep around acting a fool. But if y'all break the rules, the big bro got the tool and he let that shit go like a boom. So they coming up soon, so y'all best to say two big bodies, so y'all better make room.
You gotta wait till the music go off, Felice.
Sometimes I feel like losing my skin. I ain't got shit to prove, but I got shit to lose, so I can't go around acting a fool. But if y'all break the rules, the big bro got the tool and he let that shit go like a boom. So they coming up soon, so y'all best to say two big bodies, so y'all better make room. Ain't no shit, but I ain't not Kazam. Cooking shit up without a frying pan. Look at scripts on my director shit, but I'm moving up to be casted as an extra man. I'm moonwalking and I'm smooth walking to the top. You bitches lose too often. If it ain't about it, I got it subtract. I'ma multiply cash and division the rabbit. Put it together and now you are having. That's what they like to call super mathematics. Stay and supporting, but
I ain't mad at it.
Yes. I ain't part of the four, but I stress like elastic and part of the four, but they call me fantastic. And had it in a long time, just like Jurassic. And been here a long time, but I'm still a classic. So it's a classic and in martial arts, they make natural.
No. That way you got
They
it.
can't see it, but just look at that.
I don't know then. No, I'm looking at it right here. You can see right here.
And it's just a start, so y'all better come hard. Your whole favorite thing, I'ma tear all your part. Smoking on dope and it's like a fart. It's only sour face, body so tired. That's on my chest, Superman shit. Your mind is well, go call me Clark. Getting hoes of sick when I drop my shit. Pep don't make these hoes gas.
That's the topic.
Like a scarf. I'ma last forever like a scar. I wanna sit with them, but I don't go with them. These presents just not up to par. And I know that I'm gonna make it far. I'm the target, they throw them like darts. I'm a beast when I see these bitches being got them thinking I'm a shark. Shining brightly, I'm frozen in the dark. This be playing like I'm in the park. Think I want a nigga, bitch. How you figure coulda had him, but he is a narc. Bitches jocking my moves, imitating my moves, but I will not let these hoes make me lose my cool. The name is Sin Baby Scream.
You got it?
It's true. Go try and play me.
You on?
Mevo? Bitches jocking my moves, imitating my moves. Sometimes I feel like
I gotta hit that one.
I ain't got shit to prove, but I got shit to lose, so I can't go around acting a fool.
Huh?
The big boy got the tool and he let that shit do like a boom. So they coming up soon, so y'all best to say two big bodies, so y'all better make room. Bitches jocking my moves, imitating my moves. Sometimes I feel like losing my soul. I ain't got shit to prove, but I got shit to lose, so I can't go around acting a fool. But if y'all get the rules, the big bro got the tool and he let that shit go like a boom. So they coming up soon,
You put the Mevo to the modem? You put the Mevo to the modem? It's still lagging. Bad. Did you change the that thing to 360 or whatever the heck it was?
Alright, be in tune.
I don't, unless it's saved from last time.
Oh, I don't know. It's lagging a bit. So hi everyone. Thank you for tuning in. Sorry, we're a little bit late. We had some technical difficulties. We're still trying to deal with our internet. The company that was supposed to come and help us upgrade our internet or give us more, I believe, megabits, has been very unreliable. So we're still stuck in our dilemma. if you know any internet companies other than the ones that we all use in our homes, you could let us know. So thank you for tuning in. This is our 9th episode. I'm Cynthia.
I'm Hamid.
And today we're going to continue with our topics of landlord-tenant. Last time we were
Tenants'
here,
rights.
the last time we were here, we I feel like, we kind of both felt like we rushed through it. So we're going to try to slow it down and give you more information. Now, we do need to give you our mission statement. So Shakira, if you could come and give us our mission statement, that would be great. And then she could let you also know where we're streaming from. We're streaming from 3 different places. Hey, hon.
Hello, how are you? Hi, everybody. Beyond Reasonable Doubt is a visual podcast series focusing on the legal system as it impacts and infiltrates our everyday existence. The mission is to free our minds through sharing knowledge and experiences in order to promote awareness, inspiration, and self-love.
Yes.
We're streaming from Instagram, BYRD Podcast, and also on our YouTube channel. Please go to subscribe. The link is in the bio. And on Facebook as well, BYRD Podcast Series.
Beyond Reasonable Doubt on Facebook. And we're live on Mevo. That's the live streaming that we're doing, that we're having the problems with the lagging. And then also you got Hamid's there, which is
Twin Reed
Street on Instagram.
okay. So and we have the call-in number 973-877-3737. I did get some messages. And we have our website that is if you go into Facebook, you can see the website link. I got some emails and I also got some comments on YouTube, so we'll go over that as well. I want to thank everybody for tuning in. I appreciate all the questions, and you can feel free to call, but if you're not comfortable with that yet, then you can continue to send me emails and I'll address your questions and you can remain anonymous.
Thank you.
Thank you, honey. So the first question that I had was about payment of a late fee. So the question was, in terms of a late fee, which we'll say if rent is due on the 1st and you don't pay it on the 1st, when will the late fee be assessed? Well, we already discussed in New Jersey, you get a 5-day grace period, right? 5 business days. So the question was, is the 5th day when you mark the money order or date the check, or is it when the landlord receives the money order?
No, that wasn't the question.
No, that's not your question. That was the question that I received via another
text.
Yeah.
Message.
Right. So the answer to that is look at your lease. Your lease should tell you what the terms are with respect to what is considered late, when is the 5th day, and when is beyond the 5th day. And it also should tell you when how you can make payment. So if the lease says something like the 5th day will be considered as the day that we receive your rent check, then you know that you have to make sure the rent check gets there by the 5th. If it says that you can postmark a money order or a check, that means that you have to go to the post office by the 5th so they can postmark it, and you'll be good and you won't be assessed a late fee. And the other answer is the marking on the post order, or the money order or the check usually does not control. So even though you might write down on your check the 5th and you don't send it out until the 10th, then you probably will be assessed a late fee, because the landlord will probably go by when they got the check as opposed to when you put the date on the check. And then we had another question, and your question went to the reasonableness of a late fee. How much can they charge? And then there was another question about proof of payment. Always get your receipt. I know a lot of people like to pay cash for their rents, and they assume that the landlord is going to mark it and as received, and if they go to court, they can just say, oh, well, I gave him cash. That does not always work. So make sure when you pay your rent, you either get a paper receipt that you save in the event that you have to go to court, or you get a money order. Keep your receipt. If you write a check, make sure you keep a recording of that, and save your bank statements, because your bank statements can tell you when a check is cashed. So you have to keep a paper trail with respect to any money that you pay to your landlord, whether it be rent or late fee, because that can become an issue as well if you don't record that you paid a late fee. Another question was about repairs. Whenever you make repairs, or whenever you have a request for repairs, always put that in writing. Typically, the landlord has to be put on notice, and all of this should be reflected in your lease, that there was something wrong with the apartment that needed to be fixed. If you don't put that in writing, the landlord can claim that they did not have notice of the repair, and therefore they're not obligated to fix anything unless they know about it. Written notice can be a letter. If you do a letter, you have to do it certified mail, so you have proof that you sent the letter. Always have your proof. It can never be just your word of mouth. If you text a request, that can also be proof. You just might have to print out your text if you go to landlord-tenant court. And also, if you email, that is written proof. You just may have to print that out when you go to landlord court. Some judges do not want to look at your phone to look at an email or a text. And what was your question again, Hamid?
Oh, the late fee. What's the amount? The amount that they could actually charge you on a late fee. What's the range that stops? How far they could go?
I did attempt to look up that, and I like to try to give people documents that they could look at themselves, so it just won't be that I said it. So I did find a case that talked about late fee and late fee charges, but it was in the footnote. I had a really hard time trying to find a case that was exactly on point. Most of the things that I read said that it has to be reasonable. So to determine reasonable is something that probably you would have to get to, either you would have to object to it before you sign to pay it. Like if it's in your lease and it says that you have to pay this amount as a late fee, you have to talk to the landlord and say, listen, I think that's too much. Can we negotiate a lesser?
But that may prevent you from getting the apartment, right?
It may. And that's a hard thing to do if you're trying to get an apartment. You're really not thinking about that right now at the time you're trying to get the apartment, because you want the apartment, obviously. So otherwise, you would have to wait until you get to court and let a judge decide whether or not it's reasonable or not.
But what's reasonable?
The judge can decide what is reasonable and what is not reasonable. Now, $100,
$150 late fee is not reasonable to me. But it may be reasonable to the judge.
Well, this case that I found is called Mitchell v. First Real Estate Equities. It is 287 NJ Super, 546 NJ Apdiv, 1996. And I looked in the footnote. It's footnote 2. And this is, I mean, I really had a hard time finding something on point to this.
That's 23 years ago.
I'm just telling you what I found. And it says that
Rules change.
it says that it would appear that back then $75 was excessive in relation to a monthly rental of $620. So I don't know what percentage. I don't know what percentage $75 is of 620.
Oh, it got to be some relation to the rent, the amount that you pay.
This is what this footnote says, that essentially it has to be connected to. It has to be proportionate to the amount of rents that's charged. So if it's
that sound reasonable. That sound reasonable.
And you saying like you said 100 on 8 you find unreasonable. Now what's the percentage of that?
No, what I'm saying is I like the fact that it has a relation to the based off the rent, not off of your feelings and what you think you should charge. Like a landlord could just be like, yo, all right, your rent $800, but if you late, I want there's $100 late fee. Like, nah, you should fall into the set amount of rent that I'm paying. If it's $25, $30, I'm alright with 25, 30, even 50. Anything after that, but yeah,
I think that probably if it's like 5 or 10%, that's probably reasonable. I think if they try to charge you per day,
so 10% of 800, what's that, like $40?
10% of 800?
Oh,
yeah,
no, $80. Yeah, $80.
So
damn,
he's
nah,
like,
that's bad. That's no good.
well,
Nah, that's not
5. I think that
good. That's
probably
still close to 100. Yeah, this is 5%.
A lot of people used to charge 35.
That's like $40.
I was trying to find, there was another case that I saw in here that talked about it. It was called I couldn't find the actual case, so I didn't want to really talk about it. But this was a case, I think, where the person was trying to charge, the landlord was trying to charge a daily fee, and they were like, no, that's too excessive. But if I think of where it was, I can
I could accept the fee because you inconveniencing the landlord when you paying your rent late.
Yeah, because landlords do have to pay the mortgage and things for the house. So, I mean, it's fair for them to charge some late fee, I would think. But I don't think that it should be such a burden, because if you're having problems paying your rent, just to add on a late fee that's cumbersome is not helping you.
Yeah.
You still gonna have right.
It's obvious that you got problems. You know what I mean? If you paying your rent late,
yeah, I'm trying to look up all this stuff. These people are having an argument about whether it should be 5%, 6%. It's really not clear. I'll keep trying to look and see if I can.
So it's safe to say that it's vague.
Yeah, another vague. Well, I don't even think that there's really a concrete law on it. Like the other vague statutes we were talking about, there was law. It was there. It just was broad. But I don't think that there is anything that I can find in here. And maybe if somebody out there can find it, I don't know, that says that there is a particular law that says how much you could charge late fee for rent. I didn't see it. I looked all weekend and some of last week, and I couldn't find it. So now let's go on to talk about the rest of these oh shoot,
You talking about the rent deposit?
yeah, we're gonna go to, if you guys remember, we were telling you that tenants rights manual, The book, it was called, what's the name of it? Tenants' Rights in New Jersey, a legal manual for tenants in New Jersey, and it was written and published by the Legal Services of New Jersey, with a copyright date of 2014. Legal Services of New Jersey put this together. So the last time we were talking about it, and I spent most of the time talking about my horrible tenant situations, and I think we glossed through a lot of the things. So we're going to try to take it slow this time, and start on chapter 3. If you guys were able to find it, start on chapter 3 and talk about security deposits. There is a limit on security deposits. The landlord cannot charge more than 1.5 months times the monthly rent for security. That's the limit, and this manual, it cites to NJSA 46:8-21.2. Has anybody ever had a landlord try to charge more than 1.5 months rent for a security deposit? No? So I think that, landlords probably are pretty fair on that end. They can charge less if they want, but that's the maximum that they can charge. Now, we also talked about that the landlord has to put your security deposit in the bank. They can't spend it. They can't put it in with their own money. They got to put it separately in a bank.
Yeah, because right here it says a security deposit is money that belongs to the tenant but is held by the landlord in trust.
Correct.
Security deposit is made to protect the landlord against the tenant's failure to follow his or her responsibilities as stated in the lease.
So that means that if there's damage done to the property, then the landlord can try to use the security deposit. Sometimes if rent's not paid, the landlord can try to recoup that from the security deposit. But a lot of those issues you have to address in court. So they have to tell you that it's in a bank. They have to put in writing the name and the address of the bank where the deposit is being held, the type of account, and if interest is accrued on it, they have to put that as well. And it says that it has to be given to the tenant in writing within 30 days after the tenant gives the deposit to the landlord. So within 30 days, they have to do that. And typically, if you look at your lease agreement, a lot of landlords put it right there. They don't wait the 30 days. When you sign, they'll say that the security deposit went into whatever bank account.
Well, they got this other section that says this includes non-payment of rent or damage done to the apartment by the tenant other than ordinary wear and tear. Read your lease carefully before you sign it. The lease should state clearly where the landlord will hold your security deposit and under what conditions it will be returned to you when you move out. The security deposit law now says that a landlord can't take any money from the tenant's security for repairs, rent due, or anything else while the tenant still lives in the apartment or house.
Well, that's the part where we were talking about before when they said that if they don't tell you where they put the deposit, if they don't tell you that, then you're entitled to use that money. They have to do it within the 30 days, remember. Then you have to use that. You can use that money towards your rent. You have to write them, the landlord, a letter, and you have to say, because you have failed to tell me where my security deposit is within the 30 days as required by law, please apply my security deposits to any rents past due or any rents in the future. And if they do that, they cannot ask you for any more security deposit.
So once they use your security deposit, if you tell them to use your security deposit towards your current rent that'll be coming up,
you could use it towards the rent that you got due, that if you past rent or future rent.
And then after that point, you will be paying normally the normal rent
after
month.
They apply it for whatever month or month and a half, really, because if you gave a month and a half security, then after it's applied, then you have to continue to pay your rent. So if you need like a month and a half to catch up with some stuff, and they didn't tell you where they put your money in the bank, then you could use that as a means of paying your rent. Now they're saying right here, always make sure that it's certified. You got to send it certified in the mail, that letter. I would not suggest that you text it or email it or any of that. That one, put in the mail, certified return receipt requested. And there's a whole different thing about interest, because if the apartments are over, if they're over a certain amount of apartments, I believe it's 10. It's in here somewhere. Then it says right here, interest on your security deposit. The Rent Security Deposit Act requires landlords who rent 10 or more apartments to place tenant security deposits in either an insured money market fund or a federally insured bank account. The account must pay a rate of interest set at least quarterly and equal to the average rate of interest paid by the bank on money market accounts. So if you live in an apartment building that has more than 10 apartments, your landlord not only has to put the money in the bank, they have to let it accrue interest. And you have to get notice of that interest. They have to let you know, because that's money that's coming back to you. So they have to let you know what the interest is. And then there's penalties if they don't do that as well, if they don't do that with the interest. So that's in here also.
Now, the landlord has to state where he's putting your money in.
Right. So if it's Wells Fargo bank account, wherever, the Bank of America, that's where your money is.
Is it unusual that landlords do that? They don't tell you?
Well, I've been able to do that, make use of that law on at least 3 separate occasions.
And should it be stated in a lease or on a different kind of?
No, nobody's going to tell you about that.
Huh?
They're not going to tell you about that.
So you have to ask?
No, you don't know. You the only way you're going to know about that is if you watch this podcast.
Oh.
I'm just joking. If you look at this pamphlet, it has it in there. But that's not something that the landlord's going to tell you. Why would they tell you that? He's not obligated. He or she is not obligated to tell you that.
Why are they not obligated?
Because they're not obligated to tell you the law. Just like, the police not obligated to tell you the law. Who's obligated?
But I'm a tenant. If you should tell me where you put my money.
No, of course, that part they have to tell you. There's a penalty if they don't. But they don't have to tell you. They don't have to tell you what the penalty is what I'm saying.
I don't care about the penalty. If you don't tell me, then I'm gonna use that to my advantage. That's what I care about. You're
gonna use it to your advantage because now you know about this law that allows you to pay it to your rents.
Yes.
Past or future.
Yes.
But my point was, you're not gonna know that unless you study up on it. Because the landlord is just not going to tell you. And by the way, if I don't put your money in the bank, you could use it against me later. Now, when you getting your security deposit back, you're entitled to your security deposit back within 30 days after you move out. You see, we're on that section now, getting your security deposit back. You're not even
30. It's 30 days.
You're not even on the same page as me. No, you're still on the first page. Hold on. Right here.
Oh.
We're on page 13, y'all, if y'all following along. So, within 30 days of you moving out, the landlord must return your security deposit and interest if interest is accruing. If it's less than 10 apartment buildings, you don't get interest.
Oh, so you get the advantage of the interest too?
That interest is yours. So
if you living in that apartment for 10 years,
yes,
you done build interest on your security.
Mm-hmm.
And they never told you that.
I knew.
Oh, and you could take that money and go get you a bigger house if you want.
It's probably not a heck of a whole lot of interest, but
if you've been in there for 10 years, some of us be sitting in there from apartments for 10 years and better.
How much interest you think that'll be?
Well, they didn't tell you the interest rate. You don't know the interest rate.
I think it might be let me not guess because I don't want to give out no wrong information. But now they can deduct any damages from this the security deposit, any damages other than normal, ordinary wear and tear. And ordinary wear and tear would be something like paint. If your apartment needs a new paint job after you leave, sometimes like
They take money for that?
no, they can't take money for that. It has to be some severe, it's like something more.
Yeah, like you just purposely put a hole in the wall.
Right. You tried to damage the property.
Yeah,
but if it's normal wear and tear, like you would, if you got kids especially, the paint going to be a little messed up. The walls may be after you leave. It might have fingerprints and whatnot, but it should not have a hole punched into it. Okay. Now, it says landlords cannot charge cleaning fees for tenants who leave their apartment broom clean. And that's the standard. It has to be broom clean. Somebody's saying out there that something is like 12%. I don't know. I don't know what they're saying that's like 12%.
Give us some more information, please.
If the landlord does not give you your security deposit back within the 30 days that they're supposed to give it back to you, then you can go to court. You can go to court and you can file a complaint against them. And this says you can go to small claims court and file a complaint. And it gives you all the stuff that it tells you where to go and everything. And if you prevail, you get double your security deposit. So if your security deposit was $1,000, they don't give it back to you within 30 days, and then you go to landlord tenant court, you'll get $2,000. I'm sorry, this says small claims court, which is different from landlord tenant court.
Wait, the small claims is municipal?
No. Small claim court is special civil with the max of $5,000. Unless they've changed it, but it used to be $5,000.
It is.
Okay, $5,000.
That's what it said.
The lady is saying on the phone, Karen Harris said it used to be $40 interest a year.
Which one are you watching?
I'm watching this.
You ain't supposed to be watching that. What? I don't know what she's saying. Wherever you at. Nope. Nobody. Oh, okay. Go ahead.
Said it was 40. It used to be $40 a year of interest.
Okay. I don't know. I don't know what the interest is. The next little paragraph talks about displacement. It says if you're forced to move because of fire, flood, condemnation, or evacuation, the landlord must return your security deposit plus your portion of the interest earned on it within 5 days. Okay. Before returning your money, the landlord must deduct any charges you owe under the lease agreement. This includes rent and that you may have owed before you were displaced. And the security deposit must be made available to you during normal business hours for 30 days in the city in which the property is located. So basically, they got to give you a security deposit back so you can move because for whatever reason they're kicking you out. And that happens sometimes. Sometimes if something catches on fire or whatever. So Chapter 4 talks about leases. And the first thing that they say, which is very important, a lease is a contract. A lease is a contract. So you must treat it as if it's a contract, and you need to look at it and see all of its terms. Make sure you understand it, because when you sign it, you're bound by it. That means that if you sign a year lease, you can't up in 6 months and say, oops, okay, well, I don't want to live here no more, goodbye. That's not going to work, because the landlord is going to have remedies against you because you signed the lease for a year.
Now now if your lease is up and you have the option to renew your lease or move, if you don't renew your lease, are you forced to move?
No, it usually converts into a 30-day, a month-to-month instead of the yearly lease.
Now, if it convert into a month-to-month lease, do all of the things that the landlord it still applies to you even on a 30-day basis?
Yes.
No, it doesn't.
Don't?
No. It's you're governed by the landlord tenant laws, but you're not bound by that contract. Once the contract is over,
Which contract?
the lease, which
The
is the lease.
Yeah.
So once the
Yeah.
lease is over, the lease is over. But you still have to be bound by the landlord-tenant laws, and meaning that you have to pay your rent. You can,
Just hold on.
you could get, you're subject to eviction proceedings and so forth and so on. Unless the lease says, because sometimes the lease will say, if this is converted into a 30-day month-to-month, then you're still bound by the terms that we have discussed in this lease.
All right. Now, if
But what you're not bound by is that you have to stay there a year. There's
Right.
options.
Yeah, but the security still could be returned to you when you're ready to move.
The security still stays where it is typically, and then when you move, then you still get your security.
Right.
Because the security you would have had to give whether or not you were in a 30-day month to month or whether or not it was a yearly lease.
I
Okay.
have a question.
Mm-hmm.
Person is saying, Karen is saying, what if your landlord never physically gave you a lease, but gave a copy to your rental assistant agency?
They supposed to give you a copy of it.
What if your landlord never physically gave you a lease, but gave a copy of it to your rental assistant agency?
What is a rental assistant agency?
Like HUD or something like PM or
Yeah,
Section 8.
Apartment
with
complex.
rental
You gotta go to
assistant.
rental office.
Well, you can ask for a copy of your lease. Are they refusing to give it?
She didn't come back through.
Is she moving on? Should we go on to a different section?
I think.
I had another question, but it kind of slipped my mind.
Okay, she said Section 8, but she didn't come back with the minutes.
Well, Section 8, can we go on to, can we speak about when the building is sold?
Well, if the building is sold, then
And you still got the tenants there and the building is sold to a different owner.
I think didn't we discuss that a little bit last time?
You remember that? Nah. I'm from right here, what it say? When
Have
your
you skipped
building-
on to a different situation?
Yes,
Yeah.
because I can't get.
No, but where are you?
Oh. I'm on 15. Oh, you want to,
I have moved on to 16, so I don't know
how
where
you
you
get past 16?
because we already talked about displacement. So
Yeah, you
where,
talked about displacement, but you went past when the building is sold. There you go again.
if your apartment is building or rented house is sold, the law makes it clear that the new owner must get the tenant's security deposit plus interest from the old owner. So what was your question about that?
Nah, I never knew that. Like, now, right?
Right.
Now, once the responsibility falls onto the new owner, at that point, could he make adjustments to the rent, or he have to wait till the person leases up from the old landlord?
I believe that he would have to wait until the lease is up, because he has to take over what the old landlord already has in place.
And then from that point, he can raise the rent however he wants.
Once the lease is up, then he can put his own terms and conditions and whatever he has in his lease. I think there's something in here that says that they can give you notice to leave, but I think that's in one of our other, when we were talking about all the causes for eviction. So I'm trying to go in order, so we'll just wait until we get to that.
Now the new tenant can't force everybody out the building.
The landlord,
The new landlord can't force the tenants out the building until their lease or their contract, which is the lease, is up, right?
Right. But they have to give, there's some, you have to wait until we get, just preserve that question until we get down further into the sections, because there is an answer for that, but I don't want to scroll down there and then have to come back, because we're still on security deposit on page 17.
I have a question. On to see that pamphlet?
Mm-hmm.
Okay.
We're gonna pull it right in their face again.
No, you can't see it. It's blurry.
Oh, is it?
Yes, you just read
All right. It's called Tenants' Rights in New Jersey, a legal manual for tenants in New Jersey, written and published by Legal Services of New Jersey, 2014, Legal Services of New Jersey.
Okay. I'll screenshot it.
So now we have, we can move on to the late charges. We talked about that a little bit. And this says that many lease require a late charge if the rent is not paid by a certain date of the month. The charge is supposed to cover the money lost by the landlord as a result of the late payment. Courts will enforce late charges if they're reasonable. That's what we were saying before, and spelled out in writing in the lease. The landlord cannot evict based on non-payment of late charges unless there is an agreement stating that the late charge is to be considered part of rent.
Okay, now if the landlord never stated anything about late charges and decide that he wants to evict you for paying your rent late all the time, could he do that?
That's habitual lateness, and we discussed that as one of the causes of eviction the last time.
But does that have to be stated in the lease, in his lease? Each
No, that's
landlord?
New Jersey state law.
Oh, okay.
That you can, if you're habitually late on a consistent basis, the landlord can move to evict you. It also says that if you have Section 8, the landlord cannot evict for non-payment of late fees, whether they call it rent or not. So if you got Section 8, then you can't be evicted because of you didn't pay a late fee.
Could you tell me the difference between the two, a regular tenant and a Section 8 person?
Section 8 person is one who gets government assistance that helps them subsidize their rent.
Okay, this is a question for the people.
And regular rent, people who pay market rent are people who just pay from their jobs or their income or wherever they get their money from. But Section 8 people get assistance from the government, and you have to apply for that, and you have to be given that.
So if the government is paying your rent for Section 8 and decide to be late, they don't get penalized?
No. But you know, a lot of times when people on Section 8, they have their own portion of Section 8 may not pay for everything. So even from my understanding from this pamphlet, even if you have to pay $200 over what Section 8 pays and you don't pay your $200 by the due date, you still can't be charged a late fee for that. That's my understanding of this. Landlord late charges are not allowed if the tenant did not pay rent on time because the landlord failed to make needed repairs.
That's fair.
It says under the Anti-Eviction Act, a tenant who repeats eviction provided that the landlord gives the tenant proper notice. That's one of the causes of evictions that we talked about before. Sometimes there's attorney's fees. I think we already addressed attorney fees. So, but that's a clause in there for attorney's fees. Rules and regulations. A lease will often have rules that the landlord wants the tenant to follow. Okay, well, that's self-evident.
You have 15 minutes.
Notice of repairs. We talked about that a little bit. Orderly conduct. You can't interfere with the rights of the other tenants to live peacefully and quietly.
And that's a form of loud music.
Arguing too much. Yeah. So that part That's another grounds for eviction. Pets, obviously, your landlord has to let you know whether or not you can have a pet or not. If they say no pets, then you can't have pets. That's something you negotiate directly with the landlord.
Do they have anywhere where a landlord is can't just go in your apartment because he owns the property?
You can't.
They have to give you notice, and
You
that
pay-
part
pay
is
them.
in that's on page 21 of this pamphlet. When can the landlord enter? It tells you everything right there. What if the landlord won't stay out? Well, I don't know. You could call the police. Oh, that's what it says. You can also call the police. I mean, if your landlord won't stay out of your house, I don't know. You know what? I have a story about that as well. It's very funny, but
All right, we
I
got
don't-
15 minutes
I
for
know.
the
I
story.
don't.
Let's head
No,
10
I
minutes.
don't want to. I ain't telling no more stories of mine because y'all ain't told no damn stories. What am I-
You like your story's more interesting.
Whatever. I'm not telling no
It's
more
all better
stories.
than
No,
ours.
y'all set me out. Y'all set me up.
Cream, you got a story, right?
No, he act
Yeah.
like
Yeah,
he's.
that's
What's your
See?
story?
Look, 15 minutes.
Huh?
Is that yours?
I told 4 stories last time we were here. Y'all ain't told no stories of tenants. We got a
15
landlord
minutes.
stories. Are you gonna tell your story or not?
Oh, I don't know.
What? Here, see, that's what, you know what? When your friends and your team members tell you that they on board with you, don't step out first because they will leave you to fall off the damn cliff. Will not pull you back. I done told 4 stories. I ain't got one tenant story from none of them, but that's okay. Don't even worry
Our
about
story's
it.
boring.
Don't even worry about it. Okay.
When I was in PM.
What if the landlord won't stay out, maintain renewal? It says right here, but a yearly lease that is not renewed automatically becomes a month-to-month lease when the year in the lease ends. And they say that's at NJSA 46:8-10, and they renew automatically. Changes to the lease. When the lease ends, your landlord can make changes, and they have to give you some type of notice, and you will decide whether or not you want to accept the changes or you don't want to accept the changes. If you don't want to accept the changes, then prepare to move. Ending or breaking your lease, all that stuff, you can read all of that. I'm not getting into you ending and breaking your lease.
Why not?
Because the bottom line is, if you break your lease, you're obviously going to get penalized in some way.
But it could be another reason why you ended the lease because of the conditions that you may be living in.
Well, if you break your lease without, if you move like I did because of the situation that I had with the roaches, they can try to take you to court and say you broke your lease. But I don't think any judge is going to tell you that you got to live with a whole bunch of damn roaches. So,
Or rats.
well, what did we talk about? We wasn't even talking about no rats.
We not talking about just you should.
Oh,
you shouldn't live in those
Lord, this one. He don't want to tell one story. Now he's talking about folks' rats. No, you definitely don't want to live with no rats. That's for sure. Or mice, for all that matter.
All right, so you got moving out because of bad conditions.
Yes.
If your landlord
We
refuses
just
to make
said that. You don't have.
repairs-
Listen, if your house got rats, you don't got to stay there. If you got roaches, you don't got to. You just can't break your lease because you just want to get up and leave. If you do, you're gonna face penalties, and that could mean that you would have to pay for the remainder of the lease, even though you're not there anymore. If you can't find a suitable replacement, or they don't find a suitable replacement, you might be in a jam. You can't, because it's a contract. That's what we said before. It's a contract. Moving out, yes, you can move out for bad conditions. They have death or disability. So I guess there's some circumstances you have to give notice. I guess if you obviously if a family member of yours passes away and they were living in the apartment, you don't have to continue to pay rent. You just have to let the landlord know that the person is now deceased. So they can't pay rent obviously anymore. And I guess if you're disabled, also if you become disabled, they have a clause for that here too. If they says that they don't have, if you're handicapped and they don't make it handicap accessible, then you also can break your lease, but you must notify the landlord in advance, and the notice must contain a statement from your physician that you were permanently disabled, and a statement that you asked the landlord to make the house apartment accessible at the landlord's expense, and the landlord was unable or unwilling to do it. Then you can move. Then they have this whole right to safe and decent housing. So you guys can read all of that. There's so much in, like, I'm only on page 29, and this is like a 110-page pamphlet. So I don't know if we might have to. Well, we had 10 minutes left. We might have to. We might have to continue it again, unless everybody is just. If you don't, maybe if you read it and you have questions, you could let us know either through the email or the phone or how you've been doing it, and those questions can be answered. But this is very lengthy. Talks about window guards, how to get your landlord to make repairs, the house code. If you have a serious situation with your house with lead, mold, and all that, you can always call the housing, code inspectors.
Code enforcement.
The code enforcement for your municipality. They'll come out, they'll cite the landlord.
You got heat requirements too, right here.
You got to have heat. Those are serious conditions that the landlord must have. If they don't, you call the city, and you could either fix the problem yourself, or you could withhold your rent under those types of situations. But all that's in here. Using rent to make repairs, repair and deduct. That's on page 35. Rent increases is chapter 7. Yeah, you could go on and on and on and on and on. It's very lengthy. So we can't cover every single thing in here, but I think we've covered all the very pertinent stuff between last podcast and this podcast. We went over basically everything that you needed to know.
You have it? You do?
So, does anybody, we got 5 minutes left. Does anybody have anything that they want to add? If they want to say anything, I got something quickly. I have another ism. And
explain ism to the people.
It's an irresponsible social messaging. And this is, I'm going to call.
Please don't abuse this word.
Ism. And I'm going to call this one a Kirk-ism, because I watch all of the Love and Hip Hop franchises. I love them, and I love who is it? Miss Mona Scott, for giving me such entertainment on the various days of the week. But my Kirkism is this: Kirk and Rashida, they're a couple on the Atlanta show, the Atlanta franchise, and for all the seasons except for this particular season, Kirk has cheated on her, disrespected her, and even had a baby on her. So this season, they're portraying Kirk and Rashida as if they're this wonderful couple, as if we forgot all prior seasons and that all is forgiven. Well, I just want to say to the young ladies out there, do not fall into the Kirkism trap. It is not okay. As far as, and this is one woman's opinion, and it's related to the law, because yes, there's a baby involved, and now somebody got to pay child support, so that those funds come out of the joint marital property. So for these two couples to come back and act like they're the couple of the year after all these things happen, and as if we did not see all that other stuff, that is irresponsible. That man, Mr. Kirk, did not have to pay one darn penalty for doing what he did. And Miss Rashida is on there smiling and hee-hawing like she's the happiest woman in the world. I, for one, think that that's a Kirkism. And ladies, don't you fall for it. What you think, Hamid?
I can't relate. I don't watch that kind of stuff.
What do you mean? But I just said with the story, the man had a baby.
I kind of blocked you out of this.
You ain't got nothing to say? Do you want to plead the fifth, sir?
There's nothing to plead. I was.
How would you block me out in the middle of the podcast and you're ignoring part of the whole conversation?
While you was talking about
but that's very rude. Should I give you an ism?
No.
No, because we're supposed to be having a podcast together. I listen to you when you talk.
Is Darts man throwing at you like that?
Do I not listen to him when he talks? So why would he tune me out?
Nah.
I think that's very rude. You owe me an apology.
I gotta watch the show for me to see what's going on.
I just told you what went on.
But that's your side. I remember I told you.
It ain't no side, Miss Patrick. Shakira, you watched the show?
Yes,
Is that not what happened?
Let me tell you the new
That's
word
what happened.
for the people now. You got your story, her story. No, you got your story, the truth, that person's story, and then you got the horse's mouth.
Well,
I didn't watch the show to hear it from the horse's mouth.
I find that unacceptable.
I didn't watch the show. I might have my own opinion on what happened. I didn't
they
get
were
to see it.
together for a very long time ago. Since she was a teenager.
That's how you feel. You said it was your opinion.
That's my opinion. Well, no, ain't nobody. And also, I asked you to try to find some isms yourself.
I don't like the word ism.
Yeah, I know. I know. That's what you
use
told me
ism?
before.
I gotta look for
Could you tell the people how you came up with this word?
What irresponsible social messaging? It's when people who have a big platform convey a message to the masses, and I think it's irresponsible. Some of the
made
messaging.
this word up?
What do you mean? I didn't make up the words. I made up how I applied it to our particular situation. And when I talked about colorism, but colorism is actually a phrase. I didn't make that up. Mm-hmm. That colorism is when they talk about people and the issue of color in a black folks community, and they call that colorism. So actually, I didn't make up the ism, but my take on it, I call it irresponsible social.
So could we say stupidism?
No, because this is can I refer you to the mission statement? We cannot call anything stupid.
No, I'm not saying. I'm just saying, could you use that in that form too? Stupidism?
No. It's
Sloppyism?
No. It's
smartism.
irresponsible meaning.
Irresponsible meaning that you have to think before you speak or before you present. And I'm not mad at Kirk and Rashida. If they want to be together, that's fine. That's why, hey. Good. Lovely. But what I'm just saying is the message. How do you come back after all those seasons when he's doing all this dirt to you, and now you're on here smiling like, we have our ups and downs.
It might be scripted.
Oh, as a way to make money. So therefore they're doing what Steve Harvey suggested. That you, in order to make money, that you lose sense of your morals and your integrity. I don't know. I mean, I can't have this conversation by myself, so my co-host is going to have to level up and come and participate in this. Because we can't talk directly to the horse. We don't know Kirk and Rashida. We have to make some type of commentary on it.
But they could call in. Recite the number again. 973-877-3737.
Bye, y'all. See y'all next time. We're going to talk about, I think what we're going to talk about next time is maybe a search and seizure. When they come in your house, when the police come in your house without a warrant, with the warrant, when they come in your car, when they search your person, when they stop you. Mm-hmm. I think we're going to start getting into all of that. I think everybody good with landlord tenant. If you have any questions, you could let us know. Until then, we're going to rock out. Thank you, everybody. Go ahead. Go ahead, Bree.
I never thought it'd be this way. Usually they feel the same. Love come again, my heart's gonna land without a spell. I was trying to run away, you was trying to run away. Feel like we become loving.
End. And then share.
I like that song.
Yeah.
Should let it play a little bit longer. I like that song.
Don't take it personal, it's just how they love.
It lags.
That's you?
They have to,
And you got high notes?
You asked that same. There's something wrong with him. Something's wrong. We had the same discussion.
I remember I asked myself.
I'm trying. I gotta learn. I gotta go to school. So.
Sultan, I don't know if I did this wrong, Sultan.